Hey folks, this is attorney Sharif Silmi. I wanted to jump on and have a just quick conversation with you out there regarding some of the state of the affairs as it relates to self-petitioners. Unfortunately, we're starting to see data, particularly in the last part of 2024 and going into 2025, where the approval rate for both EB1A and national interest waiver as a general matter has gone down quite substantially. National interest waiver approvals have gone down by more than 50%. EB1A approval rates have gone down by 24%. We have not seen anywhere near this kind of impact within our petitions at Silmi Law. And I think that one of the reasons why we can attribute some of this dramatic shift, because this even like predates the Trump administration, is in increased use of AI to create surface level petitions that are not really going deep enough to merit a EB1A. So there's a lot of do-it-yourself type things that are happening, and we're starting to see the data from this quite firmly demonstrating that it's really a disaster for a lot of people. And what happens is when you create a record with USCIS, while refiling is always an option, it does create a record. So you cannot really, veer from the statements and positions that have already been taken. It's not necessarily going to prejudice your ability to refile. However, it will be determinative in controlling the way that your case is being perceived. So we want to be very, very careful about the sort of approach that folks are taking as it relates to this situation. So, making sure that we are being very careful about the situation is among the most important things that we could do as it relates to the entire EB1A scenario. So, as we move forward, one of the things I wanted to talk about today, because we have seen so much success as it relates to EB1A, particularly for those who are on EB2 and EB3 backlogs who have chargeability to India, is what do we do post approval? Like, what happens after my EB1A is approved? What are the next steps? And one of the main things that we like to think about as it relates to the next steps regarding EB1A is to make sure that the situation is such that you are moving forward with your I-485 in a very constructive and detailed manner. So one of the things that we are doing as it relates to that is making sure that the I-485 is presented with the issue of supplement J addressed. So just so that folks are aware, you do not need to present a supplement J that is a evidence of a permanent job offer for adjustment of status that's based on EB1A or national interest waiver. So I actually have a adjustment of status package for an EB1A approved case that we are going to submit. And in this case, one of the things that we clearly point out in the legal brief to the adjudicator is that you need to understand that eligibility for adjustment of status is rooted in classification as an individual of extraordinary ability under INA section 203B1A. And this classification, as recognized by USCIS regulations and the USCIS policy manual, does not require submission of supplement J. The reason why it's important to point this out is because many adjudicators in the green card or the adjustment of status process don't experience many EB1A cases. So if I just look at the data really quick of all the employment-based approved categories, so for example, Q1 2024, there were 55,000 petitions submitted and 28,000 approved. So 28,000 approved petitions Q1 2024. And of the 28,000, only 1,900 were EB1A, right? So that means that basically, it's a less popular category, and the adjudicators in particular, particularly if you're like in, a very small population state, the adjustment of status process, if you're doing it independently of your I-140 petition, would be reviewed by a local office. So they might not be as familiar with extraordinary ability cases as, like the Nebraska or Texas Service Center would be, right? So because of that, you need to make sure that you point out all these issues. And that's one of the things that we are doing to make sure that cases go through very smoothly and quickly in the I-485 process. We're addressing these issues up front. The other issue is priority date, right? Oftentimes in the I-140 phase, when we're submitting the I-140, the approval for the I-140 will come, but the priority date stated on the approved I-140 will not be the priority date that was previously given, right? So, and this is not a big deal. Your previous priority date is controlling no matter what. Under the law, your previous priority date is controlling. So you don't have to worry about whether or not your case is going to be adjudicated for a green card according to the submission date of your EB1A versus the previous priority date. Rather, the priority date of your any previously submitted I-140 is controlling whether or not that is reflected on your EB1A I-140. If your EB1A I-140 approval notice does not have your previous priority date, you don't need to go back to USCIS or ask them for a new approval notice or any of that. You just go ahead and we file your I-485. And when we file your I-485 adjustment of status, we are going to point out that according to Section 204.5 D and E of the regulations, the priority date remains valid for processing of any employment-based category that the individual applies for or qualifies for, even if the previous employment-based category was a different section. So the priority date of any petition filed for classification under EB1A, which is Section 203B, which is accompanied by an individual labor certification from the Department of Labor, shall be the date of the labor certification application. So what that means is if you have a previous I-140 that was submitted by your employer, that was accompanied with a labor certification document, that becomes the priority date for your initial I-140 approval. The subsequent EB1A case adopts that priority date. So when we're submitting adjustment of status based on self-petition, we're leveraging the labor certification date of the initial I-140 approval in order to make that claim. All right. And then we go on to say that the priority date of any petition filed for the act, which is accompanied by an application for Section A, designation shall be the date of the completed signed petition that's properly filed by USCIS. I've seen cases turn on a number of days. I mean, like right now, if the priority date is like a certain day in the month and the approval, or I'm sorry, the priority date of the initial filing could be, a couple weeks earlier because of the labor certification process, that's something that we need to leverage. So a petition approved on behalf of an individual under sections 203B1, 2, or 3 of the acts that the alien accords the alien or the individual the priority date of the approved petition for any subsequently filed petition for any classification under the act. Exactly what we just said. So in the event that the individual is a beneficiary of multiple approved petitions, the person shall be entitled to the earliest priority date. So that's exactly what we need to do and make sure of as we are pursuing these cases. So making sure that the priority date is the relevant issue, making sure that the supplement J is not going to be an issue for the adjustment of status, particularly when we have situations where the previous priority date is not being accepted at the I-140 stage because of USCIS error or laziness or what have you. So we need to make sure that the adjudicator who's making the determination as it relates to the green card adjustment of status is doing that. The other big deal that's taking place right now as it relates to I-45 adjustment of status is that they are requiring interviews for many adjustment of status cases. So when we think about the interview for an adjustment of status case, you have to understand that, again, if you're being called to, a particular location like Fresno, California, or you're in Bentonville, Arkansas, right? The USCIS adjudicator who is sitting in the field office, even if it's San Jose, right? They are not going to be great experts on EB1A. So their first thing that they're going to ask you when you sit down is, where is your job offer? Where is your supplement J? How do we know that your priority date is current, right? So these are things that you're just going to have to politely educate the adjudicator about, because many of them will not know. And I think the biggest challenge that I've seen in these interviews is, number one, the actual field officer thinks that the interview is a waste of time and hates the fact that they're even doing it, but it's being mandated by the higher ups within USCIS. And the other thing is that they have no idea what is required in a self-petition, and they don't know even how that, one qualifies. All they know is this is like an Einstein visa, and, that you need to be, Albert Einstein in order to get it. So we have to re-educate them when it comes to this. Now, the good news is that the I-45 interview is not a re-adjudication of your I-140. So you don't necessarily need to, demonstrate to the adjudicator that, like, you're, meeting the regulatory requirements of EB1A, but they can ask you about your employment history. So, like, what you do, what your profession is, how that works. So you can expect those questions. There's a lot of biographical information that's going to be needed, such as parents' information, such as, again, employment information, residence information. The most important change that has taken place to the I-485 process, independently of EB1A or anything else, is the financial aspects. We need to demonstrate financial viability, and that you will not be dependent on government benefit for any of your petition needs, or I'm sorry, of any of your living needs. So within your petition, I strongly suggest demonstrating and providing robust financial details and information so that we can show the adjudicator that you're in a very strong financial position and you will not depend on any kind of government benefits. And, that's going to really support and help your I-485 process. So the I-485 process, adjustment of status, is afforded to you as the primary beneficiary of the self-petition, and to your derivatives. So derivatives means your spouse and children, and it could be spouse, children, or stepchildren, and they will be considered your derivatives, and you can apply for them as long as they are less than 21 years old at the time of filing. So if at the time of filing they're under 21 years old, and then they turn 21 while the case is pending, so long as the dates are current, you have no issue. They will still be permitted to adjust status to a green card within that time period. So those of you who have children who are aging out, it's really important to think about, what your scenario is for adjustment of status. So if you're in an EB2 scenario and you're kind of worried or vulnerable as it relates to your employer, but your date for adjustment of status is coming up very soon, we might want to consider a national interest waiver option so that when you do file for adjustment of status, you will not be dependent on your employer for a supplement J, because that might be hard to extract. The other thing is, if you're a self-petition EB1A, or thinking about EB1A, we need to do it in such a time period that allows fully formulated evidence to develop, and that we can file your case and adjust status. So get it approved and adjust status before your child ages out. So that's going to be really important for those of you with, relatively older children. So I hope this helps. Make sure, just to reemphasize, I-485 adjustment of status is done in such a way that is taking great care to demonstrate that supplement J is not required. I-485 supplement J is not required for self-petition adjustment of status. The adjudicators often will not know this, and we need to remind them of that. The other thing is you need to put a lot of emphasis on the priority date. And if the priority date is not mentioned in your I-140 approval notice, it's okay. It's not a big deal. Just submit your previous I-140 document along with it, give the explanation, and you'll be fine. And lastly, you're likely going to be subject to an interview for adjustment of status. That is something that has been taking place. It took place in the first Trump administration. We're starting to see that again in this administration. So be prepared for your interview and reach out to us if you want help preparing for that, or if you need help just, thinking about the self-petition journey and what that all entails. So thank you guys for tuning in, and we look forward to serving you. Feel free to reach out. You can schedule a consultation at silmilaw.com, or you can reach out via email or message. Take care.